everyone. Welcome to the next session of the International Teaching Month. Today we have with us an arbitration panel on the theme ISDS Reform Regime Interaction. Celebration of law, life, and diversity is the motto of this International Teaching Month. And keeping this motto in mind, we welcome Professor Crina Baltag, Professor Katarina, Dr. Kabir Duggal, Mr. Arjun Doshi, Mr. Bruno, and Mr. Ylli Dautaj, who have kindly agreed to deliver a session on such a relevant topic. We have with us Dr. Crina Baltag, who is a senior lecturer in international arbitration at the Stockholm University and is a qualified attorney at law since 2004, with extensive practice in various aspects on international dispute resolution, private and public international law. Dr. Baltag is a member of the Stockholm Chamber of Commerce Arbitration Institute Board and is also the editor of the Kluwer Arbitration blog, co-managing editor of the ITA Arbitration Report, and member of the editorial boards of prestigious journals in the field, including the Journal of International Arbitration. Dr. Crina has been appointed in numerous arbitrations as a sole arbitrator and a co-arbitrator under the rules of the ICC, LCIA, SIAC, and CCIR Romania. We welcome you, ma'am. Next, we have with us on the panel, Professor Katarina. Professor Katarina is the Senior Research Fellow at the Institute of State and Law of the Slovak Academy of Sciences, with main focus on the international economic law, international investment law, and international investment arbitration. She works also as an associate professor in international law at the Faculty of Law of the Pan-European University in Bratislava. As a former banker, she served in 2008-2009 as an arbitrator with the Permanent Arbitration Court of the Slovak Banking Association and is currently listed as an international arbitrator in the Israeli Chamber of Arbitrators. She is the author of several monographs on the subject of international commercial and investment arbitration. We welcome you, ma'am. Next, we have with us on the panel, Dr. Kabir Duggal. Dr. Kabir Duggal is an attorney in Arnold and Porter's New York office, focusing on international investment arbitration, international commercial arbitration, and public international law matters, serving both as a counsel and an arbitrator. Dr. Duggal is a lecturer in law at Columbia Law School teaching international investment law and arbitration. He is also director and a faculty member for the Columbia Law School Chartered Institute of Arbitrators comprehensive course on international arbitration. He also acts as a consultant for the United Nations Office of the High Representative for the Least Developed Countries, Landlocked Developed Countries, and Small Island Developing States on the creation of a novel investment support program. We welcome you, sir. We have next with us Mr. Arjun Doshi. Mr. Doshi is currently working as a senior associate with Shardul Amarchand Mangaldas, Mumbai, in the International Arbitration Group. Mr. Arjun Doshi has completed his master's from the Europa Institute Saarland University, Germany, with specialization in international dispute resolution, foreign trade and investment, and European economic law. He is a recipient of the Jawaharlal Nehru Award for International Understanding and Dr. Angela Merkel Scholarship 2016, which is granted by the German Academic Exchange Service for pursuing LLM. He is also a scholarship recipient and a participant of 2017 session of Paris Arbitration Academy on investment arbitration, and a scholarship recipient and a participant of the Young ICCA DIS Skills Training Workshop at Noer LLP Berlin, Germany, on effective written and visual advocacy in international arbitration. He has had a work stint at Herbert Smith Freehills, Frankfurt, Germany as well. He worked with the firm's international commercial and investment arbitration team. We welcome him. Next, we have with us on the panel, Mr. Bruno. Mr. Bruno is a Stockholm-based associate. He works with the Roschier's dispute resolution practice. In addition to his LLM degree from the Stockholm University, he has also studied international arbitration at the Pennsylvania State University, post which he joined Roschier in 2018. We welcome you, Bruno. Next, we have with us Professor Ylli Dautaj. Professor Ylli Dautaj is the managing partner of DER Legal. He has experience from practicing teaching and conducting research in various jurisdictions, including India, Sweden, USA, UK, Turkey, and Ireland. Ylli teaches as a guest lecturer on Uppsala University's LLM program on investment treaty arbitration and is also an assistant editor on the Kluwer arbitration blog. He has taught one of in India's premier law schools, Jindal Global Law School, and is going to be the moderator for the session. I will now hand over the panel discussion to the moderator of the event, Mr. Ylli Dautaj. Please.
Thank you very much. And also, of course, in Nirma University itself, another premier law school in India. So thank you very much for this occasion, and thank you very much to all the panelists, and of course to Nikita and Shreya and the entire team for helping organizing this event. One of the major bridges, as always, of course, a big thanks to Dean Barnes, who is here with us today, who once was the person who put me in touch with Nirma University, and since then I've been a big part of this faculty. So I'm very thankful for that. But jumping then straight to the topic for today, which is investor-state dispute settlement in general and the reforms in particular. So I go to Crina Baltag first, and I ask you briefly and generally if you could explain the current ISDS reform debates.
Good afternoon, good evening to everybody. It is always an honor to be back at Nirma University, even sadly, virtually. It's always great to be on campus and enjoy all the activities during this International Teaching Week. So many thanks to the faculty and to the organizers. Ylli, briefly with ISDS reform in the same sentence is almost mission impossible, but let me see if I can live up to your expectations. So the investor-state dispute reform, I would say that was the focal point for many institutions, international organizations, academics, practitioners, and the like in the past years. And I know that we'll later discuss and focus on the UNCITRAL reform, which started in 2017, the actual discussion, the sessions of the UNCITRAL Working Group 3 on the ISDS reform focused on procedural reforms for ISDS. There have been several avenues, let's say, where ISDS reform has been tackled. And the first and foremost that has to be mentioned is in the international investment agreements. And these are bilateral investment treaties, free trade agreements, and so on. We are looking at a new generation of treaties. A new generation of treaties that is trying to address some of the concerns raised in the past years. And you'll see in particular the free trade agreements concluded by the European Union with different countries, with Canada, with Singapore, with Vietnam, and with China and so on. And the new model BITs, bilateral investment treaties as well. We also had the amendment process of various arbitration rules, and still ongoing process, the ICSID, the International Center for Settlement of Investment Disputes of the World Bank, where most of the investment arbitration cases would go, is currently finalizing the amendment process of its arbitration rules, tackling some of the concerns raised in respect of the legitimacy, efficiency of the ISDS system. In addition to this, there are other initiatives of other institutions and organizations in dealing with particular issues relevant in the context of investment promotion and protection. And I think the most notable one, and soon to be fully, let's say, given effect, are the Hague Rules on business and human rights arbitration. And to some of you, this aspect is quite familiar because we go back only a few years ago with the tragedy in Bangladesh and the Bangladesh Accords. which generated this wave of arbitration being suitable also for dealing with human rights issues, labor issues, and so on. And we had at least 2 cases with the Permanent Court of Arbitration arising from this Bangladeshi court. So the Hague Rules on Business and Human Rights Arbitration, which I think it's one type of reform and soon to be successful and fully implemented. But what you hear from me is basically the state of the process in the past years, and I would not go back too long in the discussion. But I would say that we had this continuous concern with ISDS, with investor state dispute settlement. If some of you would remember the OECD multilateral agreement on investment of 1955 and discontinued in 1998 unsuccessfully to regulate comprehensively the substantive and procedural aspects of investment law and dispute resolution. We also had in 2004 the initiative of the ICSID that I mentioned earlier of the World Bank to include in its arbitration rules provisions concerning an appeal mechanism, and finally rejected by the amendments in the 2006 of the arbitration rules. We also had obviously other debates, discussions more recently in the G20 meeting in Saudi Arabia. The T20, which is the think tank of the G20, considered a proposal of comprehensively reform the ISDS system in a constructive manner, building upon this that I mentioned OECD multilateral agreement, to have the substantive and procedural aspects dealt with in a comprehensive manner in one instrument. So one can conclude that the ISDS system so far has faced several challenges, but I would add to that ISDS is a young system that has excellent auto regulating capacity, an evolving system. And I would say that we're in different phases of the system. And what we're witnessing at this point is obviously a phase where the system is trying to find, perhaps to respond to new demands of those that are using the system. I'll stop here because otherwise I will go into issues of European Union, ACMEA, and what came along the way that kind of pushed the reforms, but probably we'll leave this for a further discussion.
Yeah, I think we can leave that for a 3-month debate panel, the ACMEA judgment itself. But thank you very much for encapsulating the background of the ISDS reform. And to spin off to a more specific and pointed question, what are the greatest legitimacy concerns? I shall say the perceived concerns, because otherwise it would open up for debate. So what are the greatest perceived legitimacy concerns?
I think the question is excellent because it highlights one of the important points that we're talking here about perceptions, and obviously, and Kabir is here in the panel, and he participates in the UNCITRAL Working Group 3 as well, and would help me in perhaps bringing into question whether we're in fact dealing with actual problems or disperceptions or perceived problems. And actually this issue was raised in one of the early sessions of the UNCITRAL discussion, and it was highlighted by the states, by the participating states, that it is necessary to make a distinction between well-founded concerns, which are supported by facts and empirical research, and non-founded concerns, which are based on perceptions. And a proper assessment should take into consideration, obviously, this founded concerns, and also to have in mind a comparator, a yardstick. Because if one says that the ISDS system is more expensive, proceedings would take a longer time, and their legitimacy concerns, one has to ask the question, compared to what? What do you think that we can take an example so we can improve the system? So this was part of the debate. And the question was, what are the greatest legitimacy concerns? And I would say that's in the eye of the beholder, because different states would come to say, oh, my concern is that I don't have enough policy powers. I don't have enough power to regulate investments on my territory. Or if I do that, then I'm hit with a claim and I'm supposed to compensate the investor for expropriating the investment. Other states would say, I have a problem with the fact that investors have this freedom of restructuring the investment and going treaty shopping. Some other states will have a concern that the investors can claim for reflective losses. So a shareholder in a company could claim for the damages against the company itself. Some other states have a problem with the fact that the third-party funders are present in the process. So I think what at least, and I'll not advance the discussion on this, but obviously the UNCITRAL working group tried to reach a consensus on what legitimacy concerns are within the working group. But we have to keep in mind that those are related to the procedural aspect of the debate. I would say that, and ICSID amendment process, obviously we're talking about arbitration rules, is doing the same thing. I think we're not at the point of actually tackling legitimacy concerns in a meaningful manner and in a comprehensive manner. You cannot dissociate procedure from substance, and this is something that was recognized in all the discussions. Just to give you the example of the most favored nation treatment standard that goes to the heart of substantive and the procedural aspects of the case. We cannot have a proper mapping of this legitimate and concerns without having a proper discussion. So I successfully failed to answer your question, Ylli.
No, you didn't, because now I will push you. No, I'm joking. So what you underscore is actually really important. And the good thing with being in a panel as opposed to in an arbitration, no one can object and say, Ylli, that's a leading question. So I will lead the question here. And I will say, if someone comes to say that two of the major legitimacy concerns would be a regulatory chill, suppose, or an investor state bias, suppose, would you feel that it's a serious threat to the regime of investor state dispute settlement? Or would you be of the more moderate opinion that it may be slightly exaggerated?
The answer is depends. It depends on the treaty. It depends on the factual metrics. If we discuss in abstract, I think we do have an attack that relies on these 2 points that you mentioned. But then, and going back to what the states themselves have argued in the UNCITRAL working group, you need to bring empirical evidence. You need to put the finger on what's happening actually. So just to give put the question in context for everybody, and I just want to say that I know that Kabir put a note in the chat, but I have to say that I'm truly impressed by the number of viewers today. So thank you very much. But to put the things in context, we're talking about ISDS cases. If you want to include the state against investor cases, which are a few, about 3-5 cases, and if you want to put even any other type of dispute resolution, such as conciliation, and including that, I don't think we have more than 1,200 cases. Okay, let's put 1,500 cases, and we're talking the whole of the ISDS system. And if you look at the statistics of arbitration institutions dealing with commercial cases, you see that some have even 1,000 cases per year. So the question is, we are looking at quantifiable data. We are looking at transparent data. This is available, obviously, because we are in the context of ISDS system, and awards are available, most of them. Pleadings are available, even hearings. I was watching yesterday the procedural hearing on the interim measures in one of the cases. That's on YouTube. You can watch it on the ICSID website. So the question is, do you have data to support this? And I'll answer it, to your question. If you look at the number of cases in which states prevail, or in which investors prevail, you'll note that in majority of the cases, there will be a favorable outcome to states. And favorable outcome doesn't necessarily mean on the merits of the case, but that is the case as well. But it's also in relation to on a word on jurisdiction, or even a discontinuance of the case, because maybe there was a settlement or simply the investor decided to withdraw the claim. So I don't think that that's supported by evidence. The system in itself was not made to be a one-way highway. If you look at the ICSID Convention, the ICSID Convention allows investor-state disputes and state-investor disputes, so both ways, allows counterclaims in the proceedings. What came to limit these proceedings to make them more one-way highway are actually these treaties, the bilateral treaties, free trade agreements, which are the work of the states. Let's put it bluntly, the states are lawmakers and law takers, but they're ultimately the ones that put forward these provisions. So the system in itself was created to be a generous one, open to investors and states alike. With respect to regulatory powers, that's obviously the same answer goes this way as well.
And on that note, could you provide the audience with two sensible reforms, ISDS reforms?
Well, I mentioned the Hague rules. I mentioned the ICSID arbitration rules being reformed, and with the ICSID arbitration, it's a complex process because obviously it's a work of the Secretariat. It results in several drafts that are taken to the states for comments and for the public to comment. But the proposed ICSID arbitration rules, they have innovative provisions. They even have expedited arbitration proceedings proposed. But I would say, and I don't want to advance the discussion on this, I was directly involved on one aspect of one proposed reform in the context of Untitled, which is the advisory center for ISDS. And I think that's a sensible, doable reform, because it goes to the heart, at least in part of it, it goes to raising awareness about what ISDS is. It goes to inform and train the users of ISDS generally, because it tackles not only arbitration, but also mediation, negotiation. It goes to those places, to those countries a little underdeveloped or without experience in this field. And I think this is a sensible approach and one that fits with everybody's interests, including investors and states.
Very good. Thank you very much, Crina. Just to summarize briefly, and correct me if I understood this right for the audience, what Crina discussed here bridges into what we will develop further with Mr. Duggal here, but she spoke briefly on the BIT 2.0. In other words, the new versions of bilateral investment treaties and multilateral investment treaties, and the fact that they are modified or amended both substantively, in other words, the law, international investment law, as well as the procedure, for example, the openness, the transparency, and the ability to put forth a counterclaim. And she gave a specific example with respect to the Hague rules on business and human rights, and also described how all stakeholders, NGOs, interest groups, international organizations, states, through, for example, the advisory board, are working together. And why is this the case? Because it's a young system with new demands. So these perceptions of the legitimacy concern are sometimes real and sometimes exaggerated. But in that light, we need to understand, why are they there? And one major factor is that international law is fragmented, and different areas of international law should or could perhaps be harmonized into one dispute regime. And in that light, I turn now to Mr. Duggal, and I ask him if he can provide a few sentences for the audience here on what is fragmentation of international law and what is regime interaction.
Thank you. Let me just start off by echoing what Professor Baltag said. I wish I was in person with all of you. The reality we find ourselves in is that in some senses we can connect better, but there is a separate, unique charm. At least I can't wait to be on a plane again. It is also an honor because, there's a lot of familiar faces here. Crina and I have been involved in 1 million different projects. Katarina, the Slovak who lives in Austria, and I have met up in Prague because why not, multiple times. Ylli, as everybody knows, is an honorary Indian. It's a pleasure to meet Arjun and Bruno. So we hope everyone enjoys this discussion. Use the chat feature to get into this discussion with us. Ylli, you were talking about fragmentation, and just to understand this, let's move back in time a little bit. Let's move back in time 100 years ago. International law was one relatively tiny area of law, the law of nations. It was largely considering things like what are the rights of ambassadors when they come to your country, how you should not kill ambassadors, right? That was your big focus of public international law pre-World War I, pre-World War II. You were concerned of really these narrow areas, consular affairs, diplomatic issues. Post-World War, we're going to see a proliferation of international law issues, resulting in a plethora of different international dispute resolution bodies. Now think about it. If you're talking about one area, international criminal law, we have so many different bodies. You have a tribunal dealing with Yugoslavia. You have a tribunal dealing with Rwanda. You have the Rome Statute creating the International Criminal Court. You're going to have a hybrid model for Bangladesh. You look at the landscape, you have different models with different standards, all of them dealing broadly with international criminal law. Now let's apply it to arbitration. We're talking about 3,000 odd. The number may reduce thanks to Europe. Let's give Europe credit for messing things up for everybody always, right? So the number may reduce a little bit, but we're still talking of a very decentralized system of law, right? We're talking different standards. We're talking different applicable frameworks, similar but different. All of them with their individual mandates issuing awards that may potentially conflict with one another. That's what we're talking about when we talk about the issue of fragmentation. This was a concept which 15 years ago was under a lot of attention in international forums. The ILC was devoted to fragmentation. I just point out, while we were talking about fragmentation, there was a separate parallel discussion happening on specialized regimes in international law. So, while we're talking about fragmentation, same issue, multiple forums looking at it, you had this parallel notion developing of the need for specialized mechanisms looking at specialized issues. These are seemingly inconsistent ideas developing at the same time. So one school of thought will tell you having 3,000 specialized bodies, treaties with specialized instruments is a good thing. We should celebrate that because it's allowing you to tailor make things to situations. There's the other school of thought, the fragmentation school of thought, that's going to tell you this is a disaster, right? You're having same issues being decided by different bodies differently. Based on how you see the world, based on your value system, one of these schools of thought will appeal to you more than the other. This is, let me just echo and I'll stop here, but this is what Professor Baltag was talking about. Your answer for the reform, your answer on where we should go, will largely depend on how you articulate the problem. And there is no consensus on what the problem is. It is one of those things, you put 10 people in the room and you will get 12 answers. We're lawyers, so 2 extra for good luck, right? Till we cannot develop a consensus on what the problem is, we're never going to come to a consensus on the solution. Long, windy answer, but I will stop here.
Thank you very much. That was indeed a very good answer. And to spin off from that, and essentially just to put some kind of context to the audience, we're talking about post-World War II virtues. We're talking about the spread essentially of liberal capitalism. And within the liberal capitalism, we're talking about the protection of private property and the enforcement of international economic law on the one hand. And we're also, of course, then talking about other specialized regimes, such as the protection of international human rights, international environmental law, and so on and so forth. So in that light, I want to ask you whether these specialized investment tribunals should take into account, for example, human rights, environmental law within their interpretation and application of international investment law.
Thank you. I mean, I think that is, in my view, the bajillion-dollar question, right? Should a tribunal be looking at human rights and environment? Well, let me give a couple of responses to that. Point number one, tribunals are being confronted with that issue. For example, an investor says the state has, under the treaty, violated expropriation, fair and equitable treatment, blah, blah, blah. That's the investor's perspective. If the state is going to come forth as a defense or as a counterclaim, Professor Baltag mentioned that, saying, no, our measures were appropriate because you were violating the environment, because we had to do the measure, it was in accordance with our international human rights obligations, the tribunal is now confronted with the issue. Whether the tribunal wants to or no, it is a live issue in front of them. Now, what tends to be limiting factors for a tribunal, the two limiting factors for a tribunal, one tends to be the jurisdictional limitation, one tends to be the applicable law limitation. Now, an investment tribunal's mandate is narrow. These are not bodies like the Supreme Court of India. There's a fundamental rights violation. You have to hear it. These are bodies that have very narrow mandates. And tribunals fear that if they're going to suddenly have to look at the implementation of Protocol 1 to the International Covenant on Socio-Economic Rights, they're suddenly straying very far from the treaty. So that becomes one limitation from a tribunal's perspective. How far may I go without really violating what the investment treaty allows me to do? Right? That's the first limitation. If you can overcome the jurisdictional threshold, the second limitation you will have is the applicable law. And this often tends to boil down to an interpretative exercise, right? Most treaties, applicable law are, forgive my French, garbage. They cover everything. Right? They'll say, host state law, international law, everything is put in. Now, the query for a tribunal is how broadly are you going to understand international law? Do you understand international law to be the treaty? Or do you understand international law to be, this may be familiar to some of you, Article 38, treaties, custom, writings of most famous publicists, right, past decisions as a subsidiary source. Tribunals tend to be reluctant to read very broad meanings, and for good reason. Like, let's just appreciate this. International law has this broad meaning, but do we really want public policy decisions on interpretation of Article 12 of the ICCPR coming out of three people who may not have specialized in human rights law? That tends to be the limitations now. Can you find creative ways to address it? The answer to both is yes. Yes, you can find ways to overcome jurisdictional limitations and applicable law limitations. But that is where I think you will see the challenges. Let me just echo one final point what Professor Baltag spoke about. The rules are created by the states. It is interesting to see that the states complain in Working Group 3, then at the same time they're negotiating treaties, and somehow the treaties have only cosmetic fixes, whereas a lot of this could be fixed by states that do a much more better job in drafting treaties. I'll stop here, but that is, again, to mention what Crina said, good question, very difficult answer.
That was very good. Thank you very much. So essentially, you touched upon, of course, the regime interaction, and you touch upon the difficulties of supposedly investment law experts enforcing international human rights, and so on and so forth. So the question here is whether an investment tribunal should be the ones enforcing a global rule of law, which can be characterized, for example, as international investment law plus. So should we have that plus? In other words, and if we should, in what sense? So one sense is, of course, to look at international human rights violations as a defense, for example, in interpreting and applying international investment law. Then the second is whether a state can bring a case against the investor for a violation of human rights as a counterclaim. And my question here is whether counterclaims used in that manner can help redress the regime interaction issue, or at least the supposed issue, and therefore at the same time elevate the perception, the positive perception, I shall say, of international investment law, one, and two, of international arbitration as the enforcer of a global rule of law.
Thank you. Again, this is a hard question, slightly easier than the prior question, but still a very hard question. On counterclaims, let me just, the general view till 10 years ago, this was the standard. And it is important to look at the past. Why were counterclaims not taken seriously? Counterclaims were not taken seriously because if an investor is in your country, right? If let's assume you have a Romanian in India, India didn't need investment arbitration to control the Romanian Crina. I'm assuming Romanian Crina, I know you have 10 nationalities, but you didn't need international law. You are the state. You had your legislative, executive, judiciary. If Crina is doing stupid things in India, this is purely hypothetical, Crina is the best, but you could use the police to enforce the law. You didn't need counterclaims, right? Now, as the system has grown, as the concerns of states have grown, counterclaims have become a real issue, right? Now, this is the point, whether things are true or not. If in a room there are 100 people and 98 people strongly feel the system is broken, the fact that it's not really broken doesn't matter. We have to address it. That is really a public purpose crisis, right? And that's where counterclaims has become an issue. Can we use counterclaims to create legitimacy? And the answer is, if we look at Article 46 of the ICSID Convention, right? Article 46 of the ICSID Convention allows counterclaims, the standard, and you see some permutation or combination whenever counterclaims is expressly allowed, right? It's the counterclaim must arise directly out of the subject matter, right? So if I, the state, want to raise an objection, it must be directly out of the subject matter. The question is, how broadly or narrowly do you understand out of the subject matter? Tribunals typically took human rights and environment to be separate disputes. And their view was, if we're going to have this, we're going to have two parallel disputes, a tax dispute and an environmental dispute. We're seeing some nascent change. We're seeing cases involving, it started with Urbacer versus Argentina. We have seen some cases involving Costa Rica, where tribunals have shown a greater flexibility, a greater willingness to think about counterclaims. So there is hope. This may be one solution to create greater legitimacy. Again, if your problem is states can sue, counterclaims becomes a good solution. The meta question is that the problem? So I'll stop here.
Very good. Thank you very much for that. And I will give you the same final question as for everyone else. Could you give us 2 examples of what you consider to be sensible ISDS reform? It can be short,
Okay. 2, if you're, the word you used was sensible. So for me, sensible in this sense is really low-hanging fruits. And I think 2 areas everybody can agree on is put page limits on the pleadings and require everything to be done electronically. Now, if you have looked at these investment arbitration pleadings, they're generally 300 to 500 pages, and they generally will have, they're more. Crina says much more. Yeah. We just cite everything. There's footnotes put in. It's just garbage. So in a court, New York courts will tell you it has to be 25 pages. If that's good enough for New York courts, that can be good enough for arbitration, right? So we need page limits. That's going to reduce costs. That's going to make us think really of the arguments, make everything happen electronically. Now, I did some work for the Indian government. All of them use Gmails and Yahoo and Hotmail. Apparently, Hotmail is still a thing. That can't be the case, okay? We want you to do things electronically, but it can't be something that a 15-year-old in a basement in Nevada can hack into the government site. You have to be a little more smart about it. But yes, we should do everything electronically. Second thing, it's just echoing what Professor Baltag said. Let's create avenues for greater pro bono representation, greater advisory roles. Let's give states more ammunition so they cannot say the system is against us. The system, as Professor Baltag said, that they have created. So I'll stop here, but these are my 2 low-hanging fruits.
Thank you very much. Well, it was very nice to hear one that is very technical, a technical suggestion, and a more broader, that is anchored in perhaps theory of ISDS and international investment law. That is a good combination. Just again, to summarize for the audience here and bridge into the next conversation. So what Mr. Duggal touched upon here was very interesting because he had us start all the way back to pre-World War I and World War II and explain that the world was a much different place. We started with the law of nations, which was to some extent limited to how we treat ambassadors or envoys, etc. And we moved to a post-World War II environment where we saw globalization primarily as a manifestation of capitalism. And then, of course, we have in most Western legal traditions and in terms of political theory, we have liberal capitalism. And that is really important when you analyze this issue, because with the spread of capitalism, we also need to protect private rights, and we do that through international economic law, which could include international investment law. But then, because we have a liberal capitalist order, liberal democracies, we also put emphasis on human rights, environmental law. In other words, individual rights and liberties. And that takes us to the fragmentation, which is one side of the discussion. But the positive side, which Mr. Duggal had mentioned, is the specialization. But that again raises issues of regime interaction. And in this case of international investment law and human rights, for example. And what do investment tribunals do in defense and in counterclaim? And how effective is the counterclaim regime depends on interpretation of, for example, what stems from the subject matter. How do we understand applicable law? Broadly, narrowly? Article 38 of the ICJ, do we harmonize legal regimes through the Vienna Convention on the Law of Treaties? And so on and so forth. And building on that, so building on Crina's discussion, where she highlights the development of bilateral investment treaties and the focus not only on procedure, which so many scholars and practitioners only look at, but also the substantive development, right? And taking that, the need for a substantive development as well, in combination with the procedure, hearing the voices of various stakeholders, tying it together with what Mr. Duggal was mentioning on the various conflicting regimes, we move on to Katarina that will discuss the amendments, or rather the reforms on the fair and equitable treatment standard, in particularly in light of the recent Energy Charter Treaty modernization process. And that is really important because now we have moved from the issues or the concerns in ISDS and the reform to a more neatly discussing actually how this regime interaction and the fragmentation plays out. And now we look more specifically into one specific protection that is very strenuously discussed. So my question to Katarina is, as the legitimacy debate is questioning the procedure of ISDS, the material protection in international investment law is also challenged. Do you feel that the current reforms with respect to the fair and equitable treatment clause is fair and equitable per se?
You're on mute, Professor Katarina. Forgive us.
I was so eager to start that I forgot to unmute myself. Actually, what I was saying, thank you very much, Ylli, for your question. Actually, it was one of 4 questions you assigned me with. But this first question was actually a bit tricky. So I worked on it perhaps longer than on my answers to other 3 questions. And actually, I had here 2 possibilities. I could answer this question either on a record way, in a neutral way, in a formal way. And the another possibility was to answer this question in a bit informal way, off record, and perhaps with a bit of necessary eloquence. So you asked about whether the current reforms with respect to the fair and equitable treatment clause are fair and equitable per se, specifically mentioning starting with the CETA, then the Energy Charter Treaty, and the last was the Indian model BIT. I will stick to my notes I finished just 2 hours ago, so this is a really first step. As for the CETA, I read this closed list of the equity in CETA several times, and I was just trying to imagine how all the parties, when one of them involves and one of them suggests, are going to revise the whole surely sophisticated list. Sometimes they may add something, some additionally, sometimes they may remove it to they already exhausted and also a bit amputated version of the fair and equitable treatment. Who knows? And who knows when, and when the good weather allows it, maybe the first competent committee and then another competent committee under Article 10 of the CETA will consider the parties' proposal to their satisfaction. Maybe I'm just spitballing here, but it seems to me that if we had 10 CETAs, there would be perhaps 10 satirical amputated versions of the FET prepared by the relevant parties, and we could call then the international investment law perhaps a parody. I apologize for being too ironic. I have to admit that I also reviewed the latest Dunbar's chapter on the FET in the latest volume on the CETA, and what intrigued me here was his note on Canada having such the FET clause for the first time. Definitely, thus, it is a virgin clause. And what a pity that the parties to the CETA didn't finally agree on the former draft version, which was drafted in the non-exhaustive way, making a clear reference to the custom in international law. But perhaps they didn't need it, they could invent it on their own, what the Fed was going to look like. And here I should add one more remark. When reviewing this clause 2 years ago at the conference of the Center of International Legal Studies in Salzburg in a panel with Todd Weiler and Lee Kaplan, I don't remember actually any epic course to be sang in appraisal of the CETA's version of the fair and equitable treatment. So my conclusion on the reform of the FET in CETA, whether it is fair and equitable per se, is that on account of the FET clause in the CETA, I find it inadequate and restrictive and not fair and equitable. When it comes to the Energy Charter Treaty, I actually haven't found the proper complete FET reform, but at least there are some optimistical proposals put forward. Why the Swiss proposal, of course, is the most investors friendly because it is an open-ended list of the FET obligations. And if not acceptable by all those involved in the process of reform of the FET clause in the ECT, it appears to me that the proposal of relating the FET in the ECT to always evolving IMS, the International Minimum Standard, as the PCI once saw it, could still be wiser than going for another closed list. And the last in a row was the Indian model BIT. When reviewing its FET standard in Article 3, I compared it with its counterpart in the 2017 Colombian model BIT. And here I noticed that while Colombian legislators drafted the relevant article under the specific title FET, so the fair and equitable treatment state in this model, BIT, but as a closed list, reviewable again only by the Council, which was unspecified without any reference to the IMS, however, still framing substantial elements of the fair and equitable treatment within the scope of the IMS. The Indian model BIT comprises an article treatment of investments, specifically referring to the customary international law in an introductory sentence, but then specifying 3 elements of the customary international law of fair and equitable treatment, and that's it, nothing else. So here I'm really just wondering why Professor Subedi, in his famous volume on international investment law, which is, in my humble view, the best textbook ever written on the international investment law for students, stated that India omitted the troublesome FET and MFN altogether, while not sounding very certain at the same time how many international investment agreements could India concluded with this provision in the future. And of course, I will leave an exact prediction up to you. So my conclusion on account of the FET clause in the Indian model BIT is that it is not bad, but it is also partially inadequate. And I stop here.
Thank you very much, Katarina. And Katarina and I, for the audience, we share pretty much the same view on the FET protection standard. And at least I feel that in some respects, it has not been as praised as it has been criticized. And criticize is good, because in that way you can develop the protection. But it seems that attacking the fair and equitable treatment is some kind of collecting of low-hanging fruit. But what we really need to do, and this ties me to the second question here, is to ask you, Katarina, to explain to the audience, or perhaps to us all, what was the role and the purpose of the fair and equitable treatment clause, and why was it needed to begin with for investors?
Thank you for your second question, Ylli. Actually, when I read this question for the first time, immediately the whole historical development of the fair and equitable treatments came to my mind. But then you asked me to answer your questions in 3, 4, or 5 sentences in some complex form, and not to come up with the teacher spec. So I'm not doing now. I will try to be coherent and short as much as possible. So it is needed to begin with. It is needed to begin with when it comes to the substantial protection in the international investment law with the fair and equitable treatment, because this standalone standard, as the most controversial due to its many times imprecise wording and vague wording, is still, whether we like it or not, the most frequently invoked standard in investment treaty protection, in international investment arbitrations, investment arbitrations. And it is so important that it can be simply bypassed. The whole discussion about the FET can be bypassed both in the theory and also in international investment arbitration practice. And because of the interpretative freedom that it allows, or it should allow, hopefully also in the future, at the very least, and also the level of protection that it provides to foreign investors, however being conceptually tailored and argued when it's tied to the customary international law or the IMS. Here I just scratch the surface of the fair and equitable role and propose. And as for its role, I shouldn't omit that the fair and equitable treatment in modern and well-balanced BITs stands as a norm in international law, strongly supporting the rule of law. And this is something which should always be borne in mind, namely fairness and equity. It is the sophist norm. It is not the idiot norm, because the idiot norm delivers an instant message, but this message can be broad and tricky. And the FET is the sophist norm, which is multi-layered and it is elastic, and it can react promptly to changing circumstances and also to changing needs, not only of foreign investors, but also of the whole state. Of course, the disadvantage is that it is not easy to comprehend. It is not easy to follow because it doesn't deliver an instant message like the MFN. But then it is the open texture norm, it's a sophist norm, and it is based on perception of equity in its broadest sense. So that's why it doesn't deserve to be amputated in the clause list. This is my personal opinion. I stop here.
Thank you very much, Katarina. And to spin off that answer, could you explain to our next generation lawyers, which is all the students in this, the participants in this panel, why or why not, depending on, the protection in the fair equitable treatment is very much needed in what I call building a transnational legal civilization, and whether, and if so, how its content should change?
So this last question relates to the question I've already answered. The fair and equitable treatment is very much needed to build a transnational legal civilization. It was really a very nice point in your last question. I've already mentioned that the fair and equitable treatment is a norm in international law which strongly supports the rule of law, namely the fairness and equity. And it shouldn't be forgotten that in the investment tribunals have interpreted this standard to embrace 5 principles that are elements of both procedural and also substantial dimensions of the rule of law, namely reasonableness, consistency, non-discrimination, transparency, and also the due process. And this is exactly why this standard shouldn't diminish. Even its very existence assists permanently to build the transnational legal civilization. And besides, it grants a certain interpretative freedom, although not being ultimate, not being absolute, unlike the very concept of freedom. Naturally, the content of the fair and equitable treatment evolves. The whole international minimum standard as well, the customary international law as well. And here I would prefer as a reasonably improved version, for instance, the US Model BIT 2012 FET standard, or the standard which is embedded in Article 13 of the Tokyo Resolution 2013, which allowed the standard to develop a bit freely. And unlike the FET version, which is enacted in Article 8.2, 8.10 of the CETA. So as I see it, this kind of improvement could secure such fair and equitable treatment that would stay this multi-layered, flexible, sophist norm, which supports the rule of law and can be adapted to the changing circumstances, not only on the side of the foreign investors, but also on the side of the whole state, if necessary, of course.
Thank you very much, Katarina. And just finally, the same question as to everyone else. Could you give 2 examples of what you feel are sensible ISDS reforms?
Well, I reviewed several possibilities which have already been discussed in international legal writings, and I vote for those which are less intrusive. For instance, an improvement of the interpretation of the individual international investment agreements. I would omit the ICC like scrutiny of the award at the pre-award stage, and perhaps also the precedent as well. For as long as we are without the real universal investment court. And as for the creation of the ICG like universal investment court with the worldwide jurisdiction, here I tend to stay rather skeptical, although I don't rule out the possibility of the establishment of the international or even universal investment court. But here I can imagine an idea, but this is just a vague idea, of having the World Investment Court, which could be modeled under the WTO. Here, at least, the idea of ad hoc senates, but unfortunately not arbitrators, perhaps could survive. So those were my proposals.
Thank you very much, Katarina. And just for the audience, I will say that in his book on investment treaty arbitration, Professor Kabir wrote that the proof is in the pudding. And that is essentially what I would attribute to the standard of fair and equitable treatment. As Katarina said, why do we need it? Easily. It is the most invoked standard. So obviously it is needed. That was a little bit of maybe a philosophical fallacy, but that's what I feel. And then Katarina also explained that it has to do with basic fairness and equity. And that is indeed central to the enforcement of our rule of law. More than that, it is elastic and it allows for some interpretative freedom. The content may evolve, that is true. That is true and problematic, depending on what kind of judicial philosophy that you have. And Katarina also explained another beauty with the fair and equitable treatment is that it takes into account both substantive and procedural elements of the rule of law. So thank you very much for highlighting those very important features of the protection. And with that, we will move on to Arjun and to Bruno. And I see that we are good on time, but not very, very good. So I would ask that we sort of summarize the questions a little bit. So Arjun, I will ask you a very narrow question. Can you explain the ISDS reform work in India?
Thanks, Ylli, for that. Of course, I will keep this very brief. I had intended to just take you a little back on why was there a need for ISDS reform work in India. And the short point being, there are a couple of things to bear in mind here. One was that when India liberated its economy in 1991, at the time when the government of India entered into bilateral investment treaties in 1994 until 2004-5, not much thought was put into those. So whatever model BITs that were proposed by either the developing states or the developed nations, they were just taken into account and entered into at the relevant point of time. A rude shock came in 2011 when one of the most talked about investment treaty cases, White Industries versus the Republic of India. That's when the Indian government realized that the bilateral investment treaties are sort of working against them. And thereafter, there were a flurry of cases against the government of India under various bilateral investment treaties. In fact, the government of India, the Republic of India, is the most frequent respondents in investment treaty cases as we speak. All of that combined together led the government to rethink its policies on bilateral investment treaties. And somewhere in 2015, taking cues from what happened in White Industries versus Republic of India and how various foreign investors had sued the Republic of India under various bilateral investment treaties, they thought of reforming the entire ISDS system. And as part of that, the first thing that they did was they came out with a model BIT in 2016. For the benefit of the audience here, model BITs are draft BITs that, or proposed BITs, a format that the government of India takes into account at the time of negotiating the bilateral investment treaties with other countries. So it forms the basis on which they will negotiate what clauses to put in and what clauses not to put in. But the model BIT that was published in 2016 really showed the shift in how earlier the ISDS system and the bilateral investment treaties at the time were all investment friendly. And this model BIT was state-centric. At least that's what the perception is outside India. And that is one of the reasons that is cited as why it would be difficult for the government of India to convince other host states to do so. So that happened in 2016, and post that, in 2017, India started terminating its BITs. So they unilaterally terminated, out of the total of 83 BITs that India had entered into, it terminated unilaterally 58 of them. And for the remaining 25, it proposed to enter into joint interpretative statements. Now, again, joint interpretative statements would mean that you do not terminate the existing bilateral investment treaties, but the two states come out with what is known as interpretative statements to the existing clauses in the bilateral investment treaties. And those joint interpretative statements, again, were all based on the model 2016 BIT. Now, after that, there were 3 bilateral investment treaties that India has entered into on the basis of the 2016 model BIT. The first one was Belarus, which was entered into somewhere in the second half of 2018. This was followed by Taiwan, And then very recently in 2020, we've entered into a bilateral investment treaty with Brazil. Now, of course, the Brazil BIT is quite talked about because it just has moved away from investor-state dispute settlement to a state-to-state dispute settlement, which has led investors not to initiate any investment arbitrations against the government of India. Of course, I'm not going to get into any of those right now, but those are three BITs that India has concluded after the model BIT. And thereafter, there were three joint interpretative statements that the government has been able to enter with other countries. The first one was with Bangladesh. The second one, I think it was with there were a couple of joint interpretative statements after that. Of course, there was one with Cambodia. They had concluded the joint interpretative statements, but they haven't yet signed it. And then there are discussions that are ongoing with Iran, Switzerland, Morocco, Kuwait, and a few other countries as well, out of those 25 that I talked about. So that is the reform work that India has currently undertaken in respect of the ISDS.
Thank you very much, Arjun. I think you answered another question that I was going to ask you as well, is what is the current perception of ISDS in the Indian legal community? I think you covered that a little bit, but if you want to develop a little bit, tie it together with the question on how the Indian model bid has paved the way for a new international discourse on investor-state dispute settlement, because it has. The Indian model bid has indeed been instrumental for a broader reform debate.
Sure, Ylli. So, of course, I will tie both those in. So, first, let me just tell you very quickly how model BIT is different from the existing BITs that India has entered into, and generally most states have entered into. There are a few changes that India proposed in the model BIT. One, of course, Katarina also pointed out very elaborately, is the deletion of the fair and equitable treatment clause. And instead of that, they have now put in a clause that simply talks about treatment of investments, which has broadly worded the clauses there. And of course, that is subject to quite a lot of interpretation as we go along, and if cases come out of it. Number two is, of course, the exhaustion of local remedies. India has now proposed to, has mandated exhaustion of local remedies before you could initiate an arbitration under any bilateral investment treaty. So that's, of course, that was one of the things that they have proposed in the model BIT. Third was deletion of the most favored nation treatment clause. Now, and that is directly coming out of the White Industries case, because India lost the bilateral investment treaty against the investment arbitration against White Industries simply on the basis of this particular clause. And quite unsurprisingly, they've deleted the entire clause fully from this. Of course, there are concerns that have been raised about the definition of investment under the bilateral investment treaty. And they've put in words which are quite vague otherwise. Of course, there's Salini criteria. They've tried to put in certain aspects of Salini criteria into the definition of investments. Salini criteria was otherwise quite vague, and they've made it even more vague by putting it into the model BIT. Now, of course, all of this seems to suggest that we are moving away from investor-friendly approach to a more protectionist approach, which is more of a state-oriented approach. What is the current perception of the ISDS in the Indian legal community right now? To answer this question, of course, before I get into the details of it, it's very important that recently, of course, I was doing a report for Center for Trade and Investment Law. And as part of that, we were studying the investors' perception on bilateral investment treaties. And as part of that, we had asked questions to various stakeholders into the system, some of them foreign lawyers, in-house counsels, and of course, also government representatives. And as part of that, we realized that at least the Indian counterparts didn't really have much knowledge on the ISDS system. So if you would ask me, there were certain in-house counsels, quite known as well, who didn't really care about whether there was a bilateral investment treaty put in place before they thought of making any investments outside India. That was not a consideration at all. And when we asked them about whether they knew anything on the model BIT that was proposed in 2016, again, only 10% of them knew what the model BIT was. So at least in India, the perception towards the ISDS system, one, there is lack of knowledge in the first place. And second, also the fact that whoever has known and whoever works in this field has of course felt that it would be very difficult to convince host states, the other states, to enter into a model BIT, the model BIT that India proposes to have. But we have to see, there are at least 3 countries that have agreed to the model BIT. So that's a good start, at least for the from the Indian government's perspective. But we have to wait and see how that progresses.
Thank you very much, Arjun. I think that was really interesting and a very good presentation on the situation in India at the moment. And if you would be so kind to just, as the other speakers, give us 2 examples of sensible ISDS reforms succinctly. Sure.
First, of course, I agree with everything that's said on the counterclaims. So that was one that I had proposed. The second one is, of course, there's this clause about clean hands clause for the investors under the bilateral investment treaties, right? Now, I feel that that's quite important, at least also from a counterclaim perspective as well. In the Indian model BIT, there is a clause that says that the investors have to comply with laws, regulations, notifications at the time of setting up or making the investments. Now, that's quite important because at least in one of the cases that I am aware of, where despite the investor coming out with unclean hands before the tribunal, the investment tribunal wasn't able to do anything about it, except for sympathizing with how the investors had made sure that they came out with certain things. In fact, there were open firings done on local population there, and that has been clearly cited in the treaty case that I'm talking about. So, of course, it's quite important to have clean hands clause under the BIT. And I'm taking inspiration from Mr. Duggal here, where he basically identified certain aspects which are not particularly relevant to the ISDS, but also very important to how proceedings are being conducted. And as part of that, it was quite surprising, and I put this earlier as well, that there are very, very few Indian law firms or Indian lawyers who get involved in investment treaty work. And that is primarily because the Indian government, at the time when they're asking for proposals to represent the government of India in investment treaty cases, the thresholds mentioned there are so high that, of course, Indian law firms or Indian lawyers aren't able to represent the government of India. And that, I think, needs to change because at least there are quite a lot of Indian practitioners, academics, as well as practitioners who have great knowledge in this field, who are also quite vocal about the views on investment treaty regime. And they should be allowed to participate and represent in whatever capacity they should. But it's very important that that door is kept open as part of the reform as well. I think that's it.
Thank you very much, Arjun. And I just want to say to the audience and the panelists, I know that we're supposed to go on for 1.5 hours. That's what we booked. I know that some of the panelists have a tight schedule. If there is so, feel free to leave when the 1.5 hours has lapsed, and the same for the audience, because we may consume an additional 10 minutes. I want to summarize Arjun's presentation briefly and just want to highlight that the liberation in 1991 was something very important for the discourse on India's stance on international arbitration overall. It is what is known as the post-socialist Indian era, And of course, some perceive the reception of the bilateral investment treaties as a down-the-throat situation and may not be very big fans of the Bretton Woods system and that world order. However, there is another perception of an Indian economic boom and India going from a nobody in the international arena to a major superpower. And so there are two sides of that story. And that ties us to an earlier discussion on perceptions with a big P. And, you know, we have our own experiences and our own perceptions, and it is important to see it from both angles. India's model bit is something Arjun discussed heavily. It has indeed pushed the way for a new reform debate. We call it model bit 2.0. And in this debate, reform debate, all experiences are welcome, including good and bad ones. And India has, as Arjun has mentioned, deleted some of the more important clauses, such as the FET and the MFN. The MFN clause deletion was because of a negative experience. I think that the major concern was perhaps even the procedural extension of the MFN clause, but I think that's a different story. And Arjun highlighted something else of significance, which is that India is once again taking on a more state-centric approach rather than an investor-friendly one. Whether that is good or bad, I mean, it's for you excellent students to debate. But as we discussed at the very beginning of this summary, there are two sides of the coin. There is not necessarily a down-the-throat situation, but there is also a situation of an economic boom and a new international global superpower having emerged from 1991 and onwards. With that, let us proceed to our last speaker, which is Bruno Gustafsson. And having discussed with Crina and Kabir, essentially the mental representation of investment arbitration. Now I'm using Emmanuel Gailard's words, but putting them in this context instead. We discussed the theory of ISDS plus ISDS taking into account the broader realm of public international law. We went down, or we are going down to more specific discussions. So Katarina discussed the fair and equitable treatment, which is a substantive matter. Arjun discussed a country-specific ISDS reform situation, India, which is of course topical given that this discussion is happening in India, but virtually, so we're all over the world. And now Bruno is taking on a procedural issue of investor-state arbitration. And my first question to Bruno was if he could explain briefly the work in UNCITRAL Group 3, the UNCITRAL Working Group 3. But Crina has already touched upon that. So what I will do, Bruno, instead, if you allow me to, is I would move directly to the specific question on security for cost and whether you can explain the work that has been done in the UNCITRAL Working Group 3 limited to security for costs.
Sure. And first and foremost, thanks to you, Ylli, and Nikita and Shreya and the other organizers, as well as the faculty, for the invitation to speak on this very current topic. And as to your specific question, the reform discussions regarding security for costs are mainly prompted by concerns of frivolous claims in ISDS. And in essence, this relates to the discussion on the perceived legitimacy of the ISDS system, as previously discussed. And more specifically, member states have testified to frivolous actions from investors as being a relatively common occurrence. And in these situations, states have also found it difficult to obtain reimbursement for the legal costs following a successful outcome of the arbitration. And this can be due to various reasons. For example, that the investor has no attachable assets or other enforcement-related issues. And for this reason, the UNCITRAL Working Group has discussed whether it should become easier for the host state to request and be granted security for costs at the outset of the proceedings. And for those in the audience who may be unfamiliar with the concept, security for cost in the context of ISDS means that the claimant, i.e. the investor, is ordered by the arbitral tribunal under threat of dismissal of the claim to post security for the host state's legal costs. And that amount is then held in escrow by the arbitral tribunal until the issuance of the award, including the decision on allegation of costs.
Thank you very much, Bruno. I think that was an excellent short explanation of what security for cost actually is and how it operates in ISDS. And building on that, do you feel that it is a proper mechanism to redress frivolous claims?
It's a complicated question, but in short, I would say the answer is no. So far, the UNCITRAL practice and ISDS practice at large has shown us that arbitral tribunals in ISDS have subjected security for cost to a very high threshold and only granted it in truly exceptional cases, with a few exceptions. And the reason for this is, in my view, twofold. First and foremost, the tribunal's assessment on security for cost encompasses a delicate weighing of legitimate interests. On the one hand, you have the state's legitimate interest of cost recovery, and then on the other hand, you have the interest of the investor's access to justice. Because if security for cost is granted too lightly, this would in effect prevent investors, or at least risk preventing investors with insufficient financial means to pursue claims that are legitimate and that have no frivolous elements. And secondly, labeling a claim as frivolous also implies that the arbitral tribunal has made an assessment on the merits. And assessing the merits of the investor's claim at the outset of the proceedings is complicated because it always involves complex issues of both jurisdictional and substantive nature. And thus, tribunals will, as a rule, be hesitant to come to the conclusion that a claim is frivolous, and this may be due to a fear of being perceived as having prejudged the merits of the case. And in my view, these two factors are fairly hard to overcome. And this is also the reason why I think that the standards for granting security for costs in ISDS in general will remain high also in the future.
Thank you very much for that, Bruno. And I see that we are very short on time. So what I will do, I will ask you to briefly give 2 examples of sensible ISDS reform.
Sure, and I will stay on the topic of frivolous claims in this regard. And one reform could, of course, be to loosen the standards for the state to successfully obtain security for costs. However, for the reasons that I stated earlier, I don't think that this would effectively address the concern of frivolous claims. So any revision of the current standard, which is usually described as exceptional circumstances, would be, it would be more for show, more a concession vis-a-vis member states to uphold the perceived legitimacy of ISDS rather than a procedural reform with any real teeth. So a better alternative, arguably, is to approach frivolous claims with a more holistic approach, where security for costs can remain one remedy, but aimed at dealing with more extreme cases. And as for other measures, and this is an issue that has been discussed by the working group and also by others, is to address frivolous claims under the auspices of an expedited proceeding, with provisions to address allegedly frivolous claims, as well as issues on cost allocation at an early stage. And to me, this seems more attractive than attempting to loosen the standards for security for costs. Having said that, I do not think that there is any effective way to completely eliminate the issue of frivolous claims in ISDS. and perhaps one must accept frivolous claims as an inherent feature of the ISDS system, and the negative aspects of which hopefully are counterweighed by the standard of investment protection that the ISD system grants overall.
Thank you very much, Bruno. And with that, thank you for highlighting some of the major concerns and also tying it together with what had been discussed, that the issue with frivolous claims also touches upon the perceived issues with ISDS overall, and also highlighting from a very technical aspect that the reimbursement for legal costs for states is a major issue, and also for explaining to the students that actually being granted a security for cost is difficult in practice. It is a very high threshold, and that weighing of interest is important as we discuss reform, in particular from the aspect, as you had highlighted, of access to justice. In particular, I would say for small and medium enterprises or enterprises with less liquidity, primarily because of what has happened in the host state. So that it's good to consider. And then it's also very good to consider that if you would engage in loosening this standard, you would also open up a so-called prejudgment, and you would open up for attacks on the regime and the decision itself. So thank you very much for bringing some technical expertise on the security for cost, because it is not too seldom that we as scholars forget to engage in those very important practical features. Now everyone here is a practitioner as well, but in scholarly circles, these are the discussions that easily are discussed too much in academic terms rather than what actually goes on the ground. So thank you very much for that, Bruno. We have run out of time with 3 minutes, so I will leave the floor to our colleagues from Nirma University to close this session. To all the panelists, I just want to say thank you. It is my great honor and privilege to have you all with me. To Dean Purvi, to Dean Barnes, thank you very much for being here as well, and to all my colleagues and students from Nirma University. Thank you very much.
Thank you, Ylli, for wonderfully moderating the session, and thank you, Crina, thank you, Bruno, Mr. Kabir, Katarina, and our own Arjun Doshi for joining this session. It was a wonderful session. Thank you so much.
Thank you so much for such an, thank you, ma'am, and thank you so much for such an insightful panel discussion. I express my heartfelt gratitude to all the panelists for taking out time today. Due to the paucity of time, I'm really sorry to the audience and the students that I was not able to take up any questions to the panelists. But definitely you can get their email IDs and you can direct them the questions at a later point of time. I would quickly now invite our penultimate year student Kajal Singh to deliver a word of thanks, please.
I'm extremely sorry for the technical glitch, and owing to the paucity of this time, I'll keep this brief. So I, Kajal Singh, on behalf of Institute of Law, Nirma University, extends a heartfelt thanks to Professor Katarina Chovancova, Professor Crina Baltag, Mr. Bruno Gustafsson, Dr. Kabir Duggal, and Mr. Arjun Doshi for an informative and intellectually stimulating session. ISDS system, it continues to wrestle with multiple facets, and the way we were led to charter the territory, it is indeed commendable. I couldn't agree with the Professor Stephen Barnes more that such a complex matter was made so listener friendly, and we were made to understand all the nuances in such a short period of time. I next extend my heartfelt thanks to Professor Ylli Dautaj for facilitating or moderating the session with utmost finesse and panache. Indeed, sir, we today, along with you moderating the session, we learned as to how we are supposed to moderate a session, along with learning so much. Next, I thank Professor Stephen Barnes, who with his presence adds so much of vigor and enthusiasm to all sessions. Next, I extend my heartfelt gratitude to Director and Dean Professor Dr. Purvi Pokhriyal, without whose persistent efforts, International Teaching Month couldn't have seen the light of the day. Next, I thank Assistant Professor Shreya Srivastav and Assistant Professor Nikita Koradia for facilitating this session, and for all faculty members for their constant guidance and support. I conclude with expressing my heartfelt gratitude to the technical team, without whose know-how we cannot actually put together a virtual meeting ever again. So in hope and in anticipation that these virtual gatherings will transition into physical ones soon, I thank all participants, panelists, and all faculty members for their constant support and guidance. Thank you so much.
Thank you very much to everyone. Thank you.
Thank you very much.
Thank you.
Thank
Have
you.
a very good day.